Hey guys, welcome back to Off the Record, a Cop and a Lawyer. I'm the lawyer, he's the cop. And in this episode, we're going to be talking about why it is important to know the different kinds of protection orders according to a cop and a lawyer. And specifically, we're going to be talking about three different types of protection orders: an emergency protective order, a temporary restraining order, sometimes referred to as a TRO, and criminal protective and stay away orders. So we'll be talking about what stage those usually come up in and what you should know about them, whether you are the person seeking protection or whether you're the person who is being restrained by the protection orders. So I think the first one we're going to talk about, obviously, is the emergency protective order. And, conveniently enough, it's the first one that sort of comes up in a criminal case or whenever there's law enforcement involvement. So, Cop, take it away. Tell us a little bit about emergency protective orders and how those work.
Yeah, so that's the type of restraining order that a police officer can serve to one of the parties, both of the parties, on scene of a crime. Typically, it's domestic violence. Now, the police officers don't grant it. We just issue it. So it's a standard form that we all carry around, and we go to typically a domestic violence call. Let's say the aggressor is arrested and the victim is still in the house. We call up a judge, they're on call, they call us back, and we give them the nuts and bolts of what's going on, the elements of domestic violence, and more often than not, it's granted. So we fill out the form right there, we serve the party who's arrested, and then we serve the victim. It's usually good through about 5 business days, and then that will allow you to go to court to apply for a temporary restraining order.
Got it. So 5 business days or 7 calendar days. All right. And so let me ask you. All right. So you're on scene. You do your workup. You do your investigation. You make a determination that someone's going to get arrested. Now, it doesn't automatically get done, right? Do you ask the alleged victim whether or not he or she wants an emergency protective order?
We do ask them, but a lot of departments have policies that dictate how this goes. And so even if a victim, I've had supervisors tell me, even if a victim denies it or doesn't want one, just to call the judge anyway, right? And let them know. So that ultimately it's, putting it on the judge to make that final call. If the victim doesn't want it, likely the law enforcement will still call for one. Depending on the severity. I mean, the best answer in a lot of questions, not just this one, but pertaining to law enforcement, is it depends. And that's usually the most accurate answer, because no one call is the same. No one arrest is always the same. Things change even slightly, can change the whole gamut of stuff going on. So it just depends. But typically we would still call for one regardless. Now, if the suspect, let's say, fled the scene prior to our arrival, and we can't serve that person, what would happen then is it would go to, either like some sort of folder in your station, or maybe your sergeant or lieutenant to pass on to the next shift to go try to find this person. So, if there's PC to arrest this person the next day, what have you, it's known where to locate this form so that the suspect can be served, because until they're served, it's not valid.
Makes sense. Okay. Yeah. And that's a common theme I think that we're going to be talking about is, with these protective orders, there's going to be a requirement that the person who's going to get restrained has to be personally served.
Right.
Yeah, I mean, look, obviously the one thing that I want to highlight, and we're going to, again, this is going to be one of those constant themes throughout this discussion, is that, I can understand that, let's say, you're involved in a domestic violence kind of dispute. Let's say you're the one who gets arrested. And, it's a scary experience sometimes. You're freaked out, it's overwhelming. And, you might be really upset. And then a cop comes and says, hey, look, I'm serving you with this protective order. Here's what this means. You can't directly or indirectly have any contact with him or her, right? The protected party.
Right.
Is there usually you can't be a certain distance from
100 yards is really standard from the victim's workplace, and then obviously any children that are present or, in common in that relationship. And so if you happen to find yourself on the served part of this, right, some of the things that you might be thinking about is like, how do I get my clothes? And like, can I go back the next day to get my stuff? And, my best advice is do not violate the terms of the restraining order, whether you agree with them or not. But you can call law enforcement and have a civil standby that's typically what it's called. Agencies call these things different stuff, right? But ultimately, if you're outside of the 100 yards or whatever the rules are for that restraining order, you call the cops, you say, hey, I need to go get my clothes, my contacts, my retainer, like whatever it is that you need out of that house. Because if you're served one, typically it's an immediate move out order attachment as well. And so you'd have to find somewhere else to stay until this resolves or maybe it doesn't resolve. So you need to get your stuff. And so you can call law enforcement and have them either, basically facilitate that movement. And that's what I would recommend. Don't violate it. Don't contact this person. Just call the cops, even if the cops are the ones that arrested you. I've arrested a dude, right? Served him with an EPO, and then talked to that dude the next day to help him get his stuff out of the house that he was arrested out of, right? So like, it's not personal, it's just business. And we are here to help facilitate and keep the peace, and that in that realm, that's how that would work. So that's what I would recommend.
Definitely. No, that makes a lot of sense. And one of the things that this EPO or emergency protective order is supposed to do, obviously it's supposed to create distance. And a lot of people, as far as what you're talking about regarding getting, your stuff out of the house or things to survive, hey, I got to go to work or whatever. A lot of people are thinking like, look, okay, I don't want to have to, let's say it's a guy who's being restrained, right? Like, I don't want anything to do with her. I'm not going to contact her. I'm not going to talk to her, but I'm going to contact my buddy to contact her to make sure that I can get my stuff out of the house. That is a huge mistake. And that violates, because the restraining order, right? And when I say restraining order, when we talk about this, it's generally just a protection order, right? I mean, they're interchangeable, but whether it's an EPO or some other type of restraining order, the point is, once that order is made, once it's served, you can't have any direct, and again, this is kind of the ticket, indirect contact with the person who's being protected. And even though it's not about the relationship or it's not about anything specific to you and that person, having your buddy call to figure out an exchange of clothes is still a violation. And so, and might as well talk about it now. What does that mean? All right, well, if you violate a protective order, a couple of things. The very first thing is that now you're facing a violation of a court order charge. So now it's a whole separate charge that, let's say you get arrested on a DV case and you might be facing a DV charge, or maybe you don't. Maybe the prosecuting agency rejects it and doesn't file charges. But if a report's made that you violated the protection order, then they're going to get a whole separate report, and they can definitely file charges on that. So you could have a situation where you get arrested on a DV case, there's an EPO issued, the DV case never gets filed, but because you violated the protective order, guess what? Now they're going to file, right? Now they're going to file charges on the EPO violation. And sometimes if they were kind of on the fence about whether or not to file charges on the underlying domestic violence charge, but then they get word that you violated the EPO, they're going to be like, yeah, this guy's a problem.
Right.
And so then they're going to file on everything. Potentially, right? So that is something definitely important to keep in mind. And Cop, you give a great piece of advice about just reaching out to the local law enforcement agency and having them facilitate going in and getting an exchange, of things.
Right. So I'm on the inside of this, so to speak, right? Because I have intimate knowledge about how this works, and I've been involved in these cases. I mean, numerous times, and more than that. Right. And I can tell you exactly what I would do if I was the party that was served. I would have zero contact with my spouse, right? Or the other person in this relationship. I'd have zero contact with them. And the only way I would communicate is through my private attorney or through law enforcement, and start to facilitate, the logistics of, my stuff, if there's a kid involved, those types of things. By no means would I have a buddy or anybody other than an attorney or law enforcement involved in this process, because like you said, you are likely then to get charged. Just if you're in a hole already, don't put yourself in a deeper hole, right?
And look, it's going to be tough, obviously, right? And, you just got to suck it up. It's as simple as that, right? Don't violate. Now, one of the reasons why these EPO exists is obviously to provide an easy and efficient way to get immediate protection. Right? Some kind of legal order that can keep the potential suspect or the potential defendant out of the picture. So, but it gives you some breathing room, because then if you want, right, if you're the protected party, the alleged victim, complaining witness, whatever you want to name the person. It gives you some time to go and get a longer protection order, right? A more advanced protection order. And so the 5 to 7 days gives you that breathing room where you can then, without kind of having that person around, go to court and apply for what we call a temporary restraining order. So that's the second category of restraining orders or protection orders that we're going to be talking about. So, Cop, tell me about your experience with restraining orders, temporary restraining orders, how those work, and some good tips on that.
That's one of those ones where I'm not involved in the issuance of it, right? So somebody went to court on their own and got this temporary restraining order granted by a judge. And this is the biggest misconception I think that's out there is here's a very common call for service that I'll get. A neighbor, an ex-girlfriend, an ex-boyfriend, whatever, somebody calls the police and says, hey, so-and-so is harassing me. I need you to get me a restraining order, right? Like, okay, well, if it doesn't meet the criteria for EPO, the first one we talked about, where a judge issues it basically right then and there on the scene, and both people are then given their copies. If it doesn't meet that criteria, which is, I think, probably a lot of the cases out there that I'm asked for a restraining order, I tell people, well, you got to go get one on your own. Like, I can't just give them out. That's not how it works, and that's the truth. It's just not how it works. I'm not saying that that's good or bad, but that's just not how it works. And so then I'm met with some resistance from some folks, right? Sometimes because, it's like, well, I need you to go do this for me. Listen, if somebody's bothering you to the point where you think that you need a restraining order, absolutely call the police and demand a report to be written, even if it's a courtesy report, even if it's a no title report. Agencies call them different things. You can have that done, get a case number, and just continue to follow up and continue to document these instances. But at the end of the day, you're going to have to go to court, get a date on the calendar and talk to a judge about getting a restraining order. It's one of those things where, and I say this a lot, anytime you deal with the government, whether it's the DMV or the police or, taxes, whatever it is, create a paper trail and save it. And so call law enforcement, document these incidences that are leading you to believe that you want a TRO or restraining order, and get all the case numbers, the time that you called, the officer's name, the badge number, all those things. And then you're going to have to go to court. But this is one of those times where, the person is going to have to put in the legwork to get this done.
Absolutely. And just to provide some more context about the category of cases we're talking about. We're talking about cases where usually it's a domestic violence undertone, right? So the other party that you might be trying to get the restraining order against is, either a former partner, you have kids together, certain family members, that kind of thing. So that's when a domestic violence temporary restraining order, DVTRO. There are different types of restraining orders, such as a civil harassment order. We're not really talking about those, right? That's like if you have beef with your neighbor and you want to get or some stranger, some person that, you got in a road rage incident with, whatever. You don't have any type of relationship with that person. It's not a domestic type of relationship. That's separate. We're not talking about that. In a DV TRO setting, right? Most counties in California are going to have packets that will allow the person seeking the restraining order to essentially go to the court website, type in domestic violence restraining order, and then download a packet with instructions on how to fill out the petition. And there's different check boxes. You go through that, and then you take it down to court, right? So in this petition, you write out all the different reasons why you believe that you deserve the protection, right? And then you bring it down to court, and typically a judge is going to review it that day and decide whether or not to issue a temporary restraining order. I rather, err on the side of caution and just make sure this person has protection. Now, if you're the person who's getting restrained, you're like, well, that's nice, but now I'm kicked out of my house. I can't go to my house. I have nowhere to go. I have nowhere to sleep. And how long is this temporary restraining order going to last? Well, the answer to that is somewhere between 21 and 25 days. Because what will happen is the judge will issue the restraining order, the temporary restraining order, but then set a hearing, an evidentiary hearing, about 21 or 25 days later, where there's going to be a determination potentially on that day, or if it gets continued another day, whether or not this temporary restraining order should turn into a permanent restraining order. And if it becomes a permanent restraining order, then it could last up to 5 years. So that's obviously a problem, right? So that's pretty much the process. You know, like the cop said, you can't ask a cop to, you know, help you get the temporary restraining order. What you can do is, if you're seeking to get one, is to deal with making sure that you document all the you know, interaction that you believe is negative and that rises to the level of needing protection, and then filling out that petition, going to court, filing it, and going from there.
As close as I am to this process, you know, the police are not involved in any part of that outside of providing you some documentation, right? And so I think that's, I mean, I love the explanation that you gave. I think it's like extremely valuable, it's spot on, but it's important to know and understand, and we'll get into this through, you know, at certain times this will come up, but how close law enforcement can be to a certain topic, but yet how so far away, right? Because we're not downloading the packet. We're not even giving you the packet. We're not, I mean, it's just, we're very closely related to it, but we're not the ones issuing it. It's so much different than the EPO in that regard. And so I think it's important that people understand, you know, everything that you stated, because it's extremely important.
Yeah, definitely. And look, we all stay in our own lanes, right? You know, sometimes somebody will come to me and be like, hey, I got this, you know, ticket. What does it mean? Or what is this? It's like, that's something that a cop deals with. I wouldn't be able to answer that question, right? That's outside of sort of the legalities of things. So no, I hear you. And you know, I think that the next big thing that our listeners or viewers might be super interested in is, you know, that you are the restrained criminal defense, right? I'm based out of San Diego, but this really applies anywhere in the state. If you are the restrained party, okay, you get served with this restraining order. Again, as we've said before, do not violate it in any way. Now, if you get served with this, here's something you need to know. You may be tempted to respond. You may be tempted to fill out the response, because there's, you know, forms for responding to the allegations in the petition, and submitting those and saying, I want to fight this. Like that 21, 25 days, we're going to go into court. I'm going to get up. I'm going to tell the judge what really happened. And this is ridiculous, right? I can't believe that I got kicked out of my house, can't go back, can't see my kids, can't contact my, you know, whoever. And I'm going to make sure this gets taken care of. Here's the problem. If there was an arrest, or if there's an arrest possible, or if the allegations rise to the level of potentially being charged with a crime, any statement that the restrained party makes in a response, whether in writing or orally or talking to anybody about it, can be used against them. So it can be used against them in the criminal prosecution. And, you know, a lot of times we see a situation where someone gets arrested, there's an EPO, then the alleged victim goes and gets a temporary restraining order, but there's still no answer as to what's happening on the criminal case. Will the prosecuting agency file charges or not file charges? If it's still up in the air, or if they've decided to file charges, any response to the allegations is going to potentially hurt you. You do not want to be making statements about the facts until you determine what's going to happen with the criminal side. So the biggest sort of takeaway, I think, from this side of things is consult with an attorney. Make sure that you do not make any statements, because they can absolutely come back and bite you. And so 100% keep that in mind. The other thing that you should know is that if you show up at the 21 or 25 day hearing, right, if you are the restrained party, under the law, you automatically get one request for a continuance, automatically, just by default. You can ask for it, no question asked, you get a continuance. You know, maybe it's 30 days, whatever. During that continuance period, you still are going to be restrained, right? The order is going to continue on. So again, you know, as the cop told you, don't do anything directly or indirectly to violate that order. After that, you're going to have a hard time requesting a continuance unless there's really, really good reason for it, unless there's a pending criminal case or charges. In that scenario, then, you know, the way it works is there's an unfair sort of decision that somebody in that position would have to make. Either be able to fight the restraining order or violate their Fifth Amendment right to remain silent. And because of that conflict, case law has told us that a judge should be granting you a continuance if they're pending criminal charge. And cop, have you, and look, I've had to do this from time to time, but have you ever been subpoenaed to a restraining order hearing?
Never been subpoenaed.
Yeah, and it doesn't happen super often, right? But there are times where through the restraining order process, for example, if I'm defending a guy who has a restraining order filed against them, and also a potential criminal case, what I'll do is if we determine that we're going to go ahead and fight the restraining order because we've had it so the criminal charges aren't going to be filed, right? The decision's been made on that. And then we make the educated choice to go forward and fight the restraining order. There are times when I will be subpoenaing the arresting officer initially to come testify based on the reports. So what I'll do is I'll subpoena the reports, I'll be able to view them, and then I'll have to subpoena the officer to come over and talk. So let me give you an example. Let's say that the petitioner, right, the person who's requesting the protection was noted to be like super intoxicated, right? Or there was some credibility issue of the person who's making the allegations. I'd want that cop to come and talk about that.
Right,
I'd want the cop at the restraining order to talk about, the petitioner's demeanor or credibility, any inconsistencies, so that now we have a neutral, at least in this perspective, I would consider this person neutral, right? To come and talk about what they observed. And a cop's testimony is always going to weigh heavy with a court, right? And so that's going to be something for us to do. That's going to be helpful in defending the restraining order. So there is sometimes crossover, but it's certainly rare. All right, any other tips? Any other perspective that you think is important that people should know about temporary restraining orders?
Yeah, I think two things jump off the page for me. If you are the restrained party, you can't go near your, girlfriend, boyfriend, whatever, but they contact you. Don't respond. Document it with law enforcement. It's a two-way street, and spoiler alert, not everyone's honest, right? Not everyone's truthful and honorable. So it could be a ruse to get you in some BS down the road. So for me, if let's say I'm restrained from my wife, but my wife is texting me and calling me all the time, I'm not going to pick up. I'm not going to respond. I'm just going to call law enforcement, document it, control what I can control. So that's number one. Number two is, nothing in a restraining order says that you can't use common sense. And hopefully if you need to leave this relationship or, we're on the fence about it, even if you were the restrained party, let common sense prevail, and hopefully use that experience as a tool to, make correct choices moving forward. I think that this episode would be good. In our comments, we should put domestic violence hotlines and various resources that anyone can access. There are a lot of resources available to folks that are involved in these types of incidents. And so I recommend that and they're good. I mean, some of these 1-800 numbers that we see floating around in our day-to-day life are not much more than 1-800 numbers, in my opinion. But I think in my experience, domestic violence hotlines and various resources that are available throughout the state and in your specific counties, through a quick Google search, if you're not sure where to look, are extremely helpful. These folks are passionate about helping people escape, violent situations and violent relationships. And, I recommend everybody take a good look at those and see if it's the right fit for you.
No, definitely. Great point. And to expand and jump off of what you just said too, very big point, very important point that, it is a one-way street, right? So when it comes to you being the restrained party, the order restraining you doesn't say anything about the petitioner, right, or the protected party reaching out to you. So they can reach out to you all they want. They're not in violation of any order, right? But if you respond to their contact, you are 100% in violation of an order. And then again, we're back to you being charged with a crime. If you're out on bail in a domestic violence case and then you go in front of a judge and there's an allegation you violated the temporary restraining order, your bail is going to go up, right? It's not going to be good. So that's definitely an important point. But at the same time, make sure you, as the cop said, document these contacts. Don't respond, but document them, because guess what? Then if you have to fight this restraining order, or if you have to fight a criminal case, you can say, this person made all these claims about being afraid of me and about me doing all these things. And yet, he or she's contacting me, even though she went and got a protection order. So that's going to be helpful to discredit potentially the credibility of the petitioner.
And that's if that's your case, right? I mean, if it's not clear cut, good guy, bad guy's restrained from the good guy, right? So how, real quickly, because I know we're out of time, how do you document? You can screenshot text messages. You can pull up your phone bill. I would take the name. In my phone, you're Stefano, right? Well, I could put my lady's name as Stefano and screenshot that. I mean, no one knows, right? So take the name out and let the number be seen, and have access to your phone bill if they're contacting you via phone. If you're getting any mail correspondence, like hold that stuff, right? So voicemails, save them. Those are very quick and easy tips I'm giving you right now to help document if somebody is, potentially trying to get you to violate the restraining order, or if they're violating the restraining order, how to document that.
So, all right. So the last category of things that we're going to be talking about are criminal protective and stay away orders. So on this one, let me start with this one, because a criminal protective order is usually issued at the arraignment. So let's say that, there is an arrest, or, there are charges filed the very first hearing, where you're going to be the complaint, right? The charging document is going to be officially filed in court. And at the arraignment, you plead not guilty, bail is determined, and then you set future dates. But the other big thing that happens in arraignment on certain cases, especially domestic violence cases, is that a criminal protective order is issued. So a criminal protective order is a stay away order. It's a restraining order. And it can be in addition to any temporary restraining order that was already issued. So what the criminal court does is separate and distinct from the restraining order. So let's say, for example, that the restraining order gets dismissed, or a restraining order is never filed. Let's say nobody even tries to get a restraining order, but then there are charges filed. The judge, if at the request of the prosecution, most of the time, especially in domestic violence cases, is going to issue a criminal protective order. And it's the same thing. Don't contact directly or indirectly, stay 100 yards away, et cetera, et cetera, et cetera. So all the same rules apply. You can, again, be charged with a crime if you violate. So I think that's very important. Now, on this, in the criminal protective order setting, the one thing I want to note that's a little bit different than restraining orders, sort of on the, on the domestic violence, family law, civil hybrid, that is a temporary restraining order, is that with criminal protective orders, at least in San Diego County, I can't speak as to counties all over the state, but in San Diego County, some judges, in the right circumstances and with the right argument by defense counsel and the right preparation by defense counsel, can request a no negative contact order. So it's a full protective order in the sense that it's going to be protecting the protected party, right, or the alleged victim, but you can still contact them, you can still live with the person. It just prohibits any negative contact between the parties. So if I'm the protected party, and then, a call is put in to the police because I'm yelling and screaming and throwing stuff around the house, I can then get arrested on this no negative criminal protective order.
Right. And I've gone to, again, I mean, I won't put a number on it because it's a lot, but I've gone to calls that are exactly like that. And the result is either one party gets arrested or both parties get counseled as to, again, the, terms of this order. And at this point, I have access to that stuff, right? So for unlike a TRO, where it's your packet that you have, I always tell people make copies, hold on to that stuff. Again, you're dealing with the government. So have copies and documents and documentation all day long. If it's a permanent one, right? Like you said, the terms are going to be available to us either through court records that we can access at all hours, or they're attached to someone's name, when we run them out, right? So either both parties would get counsel as to the terms of them, and hey guys, okay, this is borderline, but it doesn't quite meet the criteria, or it does, and a party gets arrested, and then, kind of we cycle back again, right? So easier said than done, I know, but again, I advise folks to use best common sense and take advantage of a lot of resources that are available to people that are, potentially in situations that might not be positive. ultimately this cycle, as you can see, can just kind of play itself over and over again. And it's very unfortunate, especially if, kids are involved, but I understand that that's the case in some ways. So right. I've gone to those calls. They're tough. People at this point, though, know the terms of their order, right? I mean, it's not a shock. And so one thing I'd like to follow up with, though, is you were talking about the arraignment. Let's, again, just to show the folks out there how separate the cops are from some of these things. How often at an arraignment is the arresting officer present in your experience?
Almost never. Every once in a while, with some sex crime cases or big domestic violence cases, there'll be the detective who kind of, oversaw everything and wrote kind of reports based on the officer's involvement. But that is kind of rare. So yeah, absolutely. Right. The arresting officer is almost never at the
arraignment. And I've never been at an arraignment or subpoenaed to be in an arraignment. So I only bring that up just to show folks how, in this world of criminal justice, the criminal justice system, here you have two opposite sides in one platform talking to you. And we've already shown a couple times in this episode how just divided they are, with sometimes zero communication to the other side, right? So right. I say that because, this world can be really confusing. It's not black and white. It's a very gray world. And it can be an arduous task to sort of navigate it. And so we just want to highlight that again to show, hopefully, the value that we can bring to folks when we talk about a lot of these topics.
For sure. No, absolutely. And, the one thing I want to make sure that I clarify too is, we talked about the criminal protective order being issued at the arraignment, and it can either be a full protective order or that no negative contact. But let's say it's a full protective order. During the pendency of the case, there can also be a request to modify the criminal protective order to make it a no negative contact. And I think some people might be out there thinking like, that's not really fair, right? I'm supposed to be presumed innocent until proven guilty. And yet there's this protective order during the pendency of the case that's prohibiting me from contacting the other party, seeing my kids or whatever, going to my house, whatever the case might be. And look, then depending on how the case resolves, right? There could be, a criminal protective order that just goes away, or the criminal protective order can now become part of probation, right? So let's say somebody gets 3 years of probation. If they decide to plead guilty to something, that criminal protective order, whether it's a full or no negative, can then withstand the probationary period. There are some orders that could last years, even past the probationary period, but those are generally criminal protective orders. Another type of order that happens once a criminal case is actually filed on the criminal side is stay away orders, right, Cop? So now it's not necessarily a person, but it's a place. So tell us about that.
Right. So that could be a prolific shoplifter can't go to Target, or wherever they steal from. It could be a person who, as a term of their probation, in a drug sales case, can't frequent a certain neighborhood, and that's determined by, boundaries of streets. Sometimes it's by a specific address, 150 yards from, whatever, 123 Main Street, right? So, those exist as well. And so it's an order that protects a place from a person. But if you violate that, if you're within that, zone, or you're in that, in that building or in that, store, whatever the case may be, it's not a discretionary thing if the cop arrests the person or not, because at the end of the day, it's a judge telling the world essentially that, this person can't frequent this one spot. And so it's not up for discretion. This is one of those times when, it's a mandatory arrest. Same thing if it's a spousal deal and they have a protection order against one, has a protection order against the other. I've seen cases where there's, both people have it on each other, which is kind of ridiculous because one would work if they wanted to. But yeah, there's various different kinds, but those stay away orders are typically a person can't go to a certain place.
And look, I think, we've covered a lot of material here today, but I think there's sort of a bottom line, right? Judges don't like it when you violate their orders, right? So that's number one. You can face charges if you violate them. Read things carefully. And then, obviously at the right time, consult with a lawyer to help navigate sort of how different sort of circumstances might merge together to create issues that you didn't even think about. For example, as we talked about the restraining order, temporary restraining order, and the potential criminal case. And so that's the bottom line. Don't violate, pay attention to the details of the order so that you don't accidentally violate. And as the cop said, it's not a two-way street. So just because the protected party contacts you doesn't mean you have the ability to contact them back. They don't void the order by contacting you.
And so, and on that note too, let's say your relationship resolved itself. You had an incident that led to some sort of protection order. You know where I'm going with this. And now it's resolved itself, and the world is, flowers and gumdrops again, right? And everything is great. You're in the honeymoon phase. Everything is good. Go to court if you don't want that restraining order to be in effect anymore. Again, it's a mandatory arrest in a domestic violence situation. If there's a person who's violating that any type of restraining order, right? It's a mandatory arrest. I don't have discretion. A judge is telling me essentially take this person into custody. And unfortunately, sometimes I've had to do that when I do know that both parties have resolved whatever issue they have. They both want to be around each other. There is no problems, but for whatever reason, the cops are now in a place, legally, and running out someone's name and seeing that, this person can't hang out with this person, right? And so that's a mandatory arrest. My hands are totally tied, and it just throws a wrench into an already complicated situation. And the dude or the lady, whatever the case may be, says, we are good now. You don't need to do all this. Like, you don't need to arrest. We're fine. If that's the case, go to court, talk to a judge, because that's the only way that you can get these things resolved are through the courts.
Yeah, what a great point. Absolutely. And I got to tell you, I've absolutely represented clients who kind of let their guard down thinking, all right, well, she's promising not to make a big deal about this, but she doesn't, it's kind of a pain to go to court and file the paperwork to get it dismissed. It's a problem, Dad. And I think that's all we have for today. Yeah.
Yep. I think that's it.
All right. Hope you guys enjoyed this. Of course, if you have any questions, send us comments, email, and, remember, read those orders, pay attention, don't violate. And if you need, contact police for help or contact a lawyer for help. And hope you guys have a great day, and we'll see you next time.
Later.